Constitution straight up.
Can I take you back, Mr. Clement, to Justice Kavanaugh's first set of questions, the interstate, and you said you're not here to tell us that it makes any sense. Do you have a theory whether or not it makes any sense about how it came to be? I mean, why?
I think that, it was a different Congress a year later. Maybe the interest groups lobbied a little different a year later. Maybe the same people weren't paying attention a year later. And again, though, I think the critical thing, though, is the one thing we can't ignore is that Congress made the deliberate judgment to treat interstate and intrastate differently. Now, if you really think they should be the same, then maybe that's a reason to not read the preemption clause to reach safety-related torts altogether, as lower courts have read the ADA. I mean, if the anomaly is really bothering you, that's the one way you can make the anomaly go away. Or I actually suppose, like the text of B is a little bit different, and it's so focused on intrastate rates, intrastate routes, intrastate services, that you could say that really, unless you're talking specifically about intrastate services, the preemption clause doesn't apply. But maybe it's best to leave all of that for a case that actually implicates B, because this is a C case. And Congress clearly said, with respect to interstate, at the moment it's creating this new exception for intrastate, brokers and freight forwarders. At the same moment, it says, what we're going to do? We're going to not treat brokers and freight forwarders the same way for interstate and intrastate. And when it comes to interstate, we're going to drop them into a preemption provision that has a safety exception. I think that's what you have to sort of try to interpret here. And then if you get to the safety exception, I think the question of whether these negligent hiring torts against a broker are with respect to motor vehicles is quite straightforward. And I think if you understand the nature of the 411 restatement tort, the whole reason that there is a negligent hiring tort in certain circumstances but not others is because you're hiring somebody to do something that has the possibility of harm, bodily harm to third persons rather. And what creates the threat of bodily harm to third persons in this context? It's the 80,000-pound motor vehicle that you're putting somebody behind the wheel of or you're entrusting the cargo to. And that's true whether it's a tort against the broker or against the carrier. And so if I hire somebody to just paint my house and they do a lousy job, shame on me, but there's no negligent hiring of a contractor tort in that context because just painting the house isn't going to pose a risk of bodily harm to third parties. So what really triggers this whole tort is a risk of bodily harm to third parties. And the only thing in this mix that poses that risk of bodily harm to third parties is the motor vehicle. So if you follow what tort we're talking about here, it really does make the connection to motor vehicles quite direct.
Mr. Clement, could another way of thinking about this really be focusing on C, as you've encouraged us to do, and how it operates, what it's doing? It seems to me that one could conceive of this as C1, Congress coming in and making a change to the status quo. This is the deregulation point that you said. And they say in that section that this deregulation is occurring with respect to the economic aspects of the system. And then the safety clause, this part that we're all focused on now, is really just clarifying to some extent that what they have done with respect to preemption is leaving the status quo regarding safety. And so Justice Thomas's point was a good one. In other words, what was the status quo? States were regulating with respect to safety, so was the federal government to some extent. And if you think of it from that kind of bird's eye view, I think it seems pretty odd for respondents to suggest that Congress was really focused on who would be able to bring a claim or how. It's sort of, that's all up to how the state was regulating. What is their tort? What is their system? Congress was just, it seems to me, in this statute saying we're not touching any of that with respect to the preemption that we are now establishing.
So I wouldn't resist one word of that. I would say that's exactly how the lower courts have approached this in the context of the ADA, where you don't have a safety exception, so your eyes don't immediately go to the safety exception. But still, courts have realized that long before, like in the bad old days of federal economic regulation, you still had state tort suits for personal injury and the rest. And so when Congress in the ADA says, all right, we want to get rid of the federal economic regulation, and we don't want the states replacing it with new economic regulation of their own, but they had no interest whatsoever in getting rid of all those tort actions. And as we say in the briefs, but I think it's quite true, actually from Congress's perspective, if you want economic deregulation, the last thing you want is a huge uptick in accidents and lots of like safety mishaps.